Lawyer slid the folder across the desk and said very quietly that what had been done to me was not negligence. It was intentional. It had a name, and that name was financial elder abuse. I sat there in his office on Wellington Street in Guelph, 68 years old, hands folded in my lap the way my mother taught me to sit in church, and I thought, I almost let this happen. I almost signed everything away without once asking why. Let me go back, because nothing about this made sense to me either, not until I started connecting the dots, and by then I'd nearly lost the house my husband and I spent 31 years paying off together. My husband passed in the spring of 2019, pancreatic cancer. 6 weeks from diagnosis to gone. We didn't even have time to say the things you're supposed to say. He was here, and then he wasn't. And I was 65 years old, living alone in a 4-bedroom house in Guelph with a vegetable garden he'd built the raised beds for, and a driveway that needed shoveling, and a furnace that made a noise every October that I'd always left for him to investigate. My daughter had moved to Halifax years earlier with her husband and their 2 kids. We talked every Sunday. She wanted me to sell the house and move closer to them, but I wasn't ready. That house was where my husband and I had spent most of our lives together. It was where we'd raised her. It was where I still felt him, in the most embarrassing and honest way I know how to describe it. My son-in-law's brother had been single for years after a long relationship ended badly. He was 42, lived in Kitchener, worked in commercial real estate. I'd known him since my daughter's wedding. He was charming in that way some people are charming, too smooth, too quick with a compliment, but I'd always chalked it up to his profession. You learn to read people a certain way when you sell things for a living. He started coming around more often after my husband died, just checking in, he'd say, making sure you're not drowning over there. He'd help me carry in groceries. He'd look at the furnace. He knew the codes and the permits and the contractors and the neighbours, it seemed, because he'd grown up in this part of Ontario and had what I can only describe as a network for everything. It felt kind. It felt like family. Then last September he mentioned that a woman he'd been seeing had moved to Guelph. He introduced her to me about 3 weeks later at my kitchen table over coffee. She was in her late 30s, well-dressed, worked in financial planning, she said, private wealth management. She had a way of listening that made you feel heard, and she asked thoughtful questions about my retirement, my benefits, my late husband's pension. I thought she was simply curious, the way people in finance often are. I didn't think anything of it. A month later, my son-in-law's brother asked if she could help me review my estate documents. Just to make sure everything is in order, he said, you've got the house, the RIF, the pension survivor benefit. It's a lot to manage alone. I'd been meaning to update my will since my husband passed anyway, so I said yes. She came over one afternoon with a laptop and a leather folder and spoke for about an hour about probate fees and the cost of going through the courts and how much of my estate could be lost to administrative fees if I didn't have the proper structures in place. She used a lot of words I half understood. She talked about joint tenancy and power of attorney and something called a bare trust. She made it sound like the most responsible, loving thing I could do for my daughter's family was to start transferring certain assets now, while I was healthy and clear-minded. Avoid the mess later, she said. Think of it as a gift, not a transfer. I told her I'd think about it. What I didn't tell her was that something about the conversation had sat wrong with me afterwards. Not dramatically wrong. Just the way a room smells slightly off and you can't locate the source. I couldn't say what it was. She'd been perfectly professional. He'd been perfectly attentive. I probably was just being cautious in the way old women are told they're being when what they're actually being is correct. My neighbour Marion is 74 and a retired family court judge. She has silver hair and reading glasses she wears on a beaded chain, and she does not suffer fools or vague answers. I've known her since 1994. She is the closest thing I have to a best friend in this city. And when I told her what had happened over the fence one morning while I was raking leaves, she went very still. She asked me to repeat the part about the Bear Trust. I repeated it. Marion said, "Come inside, now." We sat at her kitchen table for 2 hours. She pulled up the Law Society of Ontario website on her tablet. She explained what a Bear Trust actually was. She explained how it could be used legally to transfer beneficial ownership of a property while leaving the registered title unchanged, so that on paper the house still looked like mine, but in practice I would no longer control it. She explained that this was a mechanism she had seen used in financial abuse cases during her years on the bench. She had seen families torn apart by it. She had seen elderly people lose homes they had owned for decades. She asked me if I had signed anything. I said I hadn't. Not yet. She was coming back next week with the documents. Marion said, "You are not signing a single page until a lawyer of your choosing reviews every word." I want to tell you that I was angry at that point, but I wasn't, not quite yet. I was frightened. There's a difference. Anger has energy in it. What I felt was the cold, specific fear of someone who nearly stepped off the curb without looking and only realized it after. I called my daughter that night. She went quiet in a way that scared me more than anything Marion had said. Her husband, she told me carefully, had mentioned that his brother and this woman were having some financial difficulties. He'd lost a client, a large commercial account, and the woman's firm had let her go months ago. She was working independently now. My daughter had thought nothing of it at the time. She was telling me now because she was starting to. I called the lawyer Marion recommended. His name was Patrick Whelan, a man in his 60s who specialised in estate law and elder protection, and he'd been practising in Wellington County for over 30 years. When I told him what had been proposed, he was quiet for a moment, and then he said, "Mrs. Callahan, I need you to do exactly nothing until we speak in person. Can you come in tomorrow morning?" I went in the next morning. What Patrick explained to me over the next hour made my stomach turn. The Bear Trust arrangement, as proposed, would have given the woman effective control over any assets placed within it. Combined with a power of attorney document she had also mentioned, she and my son-in-law's brother would have had the legal authority to make financial decisions on my behalf, including decisions about the house, while I remained, on paper, the owner. It was elegant in a horrifying way. It was designed to look like estate planning. It was, in Patrick's words, a blueprint for stripping an elderly widow of her assets over time. He said, "This is not uncommon." He said people who do this are very good at appearing helpful. He said, "The fact that you are sitting in my office instead of signing those documents is the reason you still have everything you've spent your life building." I asked him what we should do. He said, "We document everything, every meeting, every conversation, every document they've presented to you. And then you give me a call before their next appointment. We're going to be ready." I went home, and I did something that I'm still not entirely sure I was right about, but I stand by it completely. I kept the appointment. She came back the following Tuesday with the documents. 2 of them, a Bear Trust agreement and a limited power of attorney that had been drafted in language that sounded protective and careful, and was neither. I sat across from her at my kitchen table with my hands folded, and I listened to her explain everything. I asked questions. I nodded. I said things like, "I just want to make sure I understand this properly," which was the truest thing I said in that entire hour. What she didn't know was that I had set my phone to voice memo on the kitchen counter behind the fruit bowl. Patrick had told me that in Ontario, one-party consent applied to audio recording of conversations you were personally participating in. I recorded everything. What she also didn't know was that I had already called the Ontario Securities Commission because she was offering investment and financial planning advice without, as far as Patrick had been able to determine, any current license to do so. Her registration had lapsed 8 months earlier. And what she did not know, could not have known, was that the week before I had gone quietly to a Service Canada office, and then to my bank, and then to my own estate lawyer. And I had begun the process of updating my documents, my actual documents, in a way that made the scheme she was about to propose legally impossible to execute. The house now had a transfer on death designation registered in my daughter's name. My RIF beneficiary had been confirmed. My new power of attorney named Marion, who had agreed immediately and without hesitation, and Patrick as backup. By the time she slid those papers across my kitchen table, I had nothing left for her to take. I thanked her for her time. I said I needed to think it over and would be in touch. She smiled and said, "Of course, no pressure," and left my house looking perfectly pleasant. I gave everything to Patrick the next morning, the recordings, the documents she'd left behind, the timeline of every conversation, which I'd written out by hand the night after my meeting with Marion, because I didn't trust my memory to hold all of it, and I needed it to be somewhere permanent. Patrick contacted the Ontario Securities Commission on my behalf with the full file. They had apparently already had a complaint open on her. She was not a first attempt. He also contacted the police. A detective from the Elder Abuse Unit at Guelph Police Service came to my house, a young woman who was thorough and patient and didn't once make me feel foolish for having nearly been deceived. She told me that what I had documented was significantly better than what most victims were able to provide. She said that in most cases, people didn't realize what had happened until money was already gone. My son-in-law's brother was at the centre of it. She had brought the knowledge of estate law and financial instruments. He had brought the access, the relationship, the trust, the years of family dinners and helpful favours. They had done this together, and they had, it turned out, done something very similar to an elderly man in Waterloo 2 years earlier. That case had settled out of court because the man's family hadn't wanted the publicity. This one didn't settle. The most painful part was telling my daughter, not the facts of what had happened. She was furious and heartbroken and completely on my side from the first word. The painful part was watching her process what this meant for her marriage. Her husband had not known. I believe that completely, and so does she. But his brother had used their relationship as a door into my life, and that knowledge sat in her marriage like a stone for a long time afterwards. She flew out from Halifax within 48 hours of my phone call. She stayed for 2 weeks. We updated the vegetable garden. We fixed the weather stripping on the back door that I'd been meaning to do for a year. We ate dinner together every night and watched the kind of British mystery shows my husband had always rolled his eyes at, and we talked, really talked, in the way you sometimes only do when something frightening has just barely missed you. The charges took almost a year to work through the courts. Fraud over $5,000, breach of trust, unauthorised practice in the financial services sector. Her lawyer argued that it was a misunderstanding of regulatory requirements, that she believed her licence was still active, that no money had actually changed hands. Patrick sat beside me through every hearing. My recordings were entered into evidence. The documents she drafted were entered into evidence. The Waterloo case was raised during sentencing. She received 3 years. He received 2.5, with eligibility for parole after serving a third. The judge said during sentencing that financial elder abuse was one of the most underreported and undersentenced crimes in the country, and that the sophistication of this scheme reflected not a moment of desperation, but a calculated and extended effort to exploit a grieving widow's trust. She said she hoped the sentence sent a message, though I noticed she did not say she was confident it would. I didn't feel triumphant when I walked out of that courthouse. I felt tired in a way that went somewhere deeper than sleep could reach. I felt grief, actually, not for them, but for the version of this story that could have ended differently. For the woman I might have been, sitting in a lawyer's office 18 months later, being told the house was gone. I went home and I made tea, and I sat in the chair by the front window where you can see Marion's porch, and after a while she came out to water her planters. And when she saw me in the window, she raised her hand. I raised mine back. That was enough. My daughter calls every Sunday still, same as always. We added a Wednesday call after everything happened. She worries, I know. I let her because I understand now that worrying about someone is one of the ways love works, and there is nothing wrong with being loved by your children. I've spoken at 2 seniors groups in Guelph since then, and once at a community centre in Cambridge at the invitation of a social worker who had seen the case covered in the local paper. I tell people the same things every time. I tell them that the person who comes to help you is not always the person who wants to help you. I tell them to trust the feeling that something is off, even when they cannot name it. I tell them to talk to a lawyer, their own lawyer, not one introduced to them through whoever is offering help, before signing anything related to their home, their registered accounts, or their power of attorney. I tell them that asking questions is not paranoia. Paranoia is when the fear is unfounded. What they are feeling is often just clarity. After my last talk, a man of about 70 came up to me in the hall. He said his son had been pressuring him for 2 years to transfer his condo into a family trust the son had set up. He said he kept telling himself it was normal estate planning, that he didn't want to insult his son by questioning it. His hands were shaking. I gave him Patrick's card. I also gave him Marion's number, because sometimes what you need first is not a lawyer, but a person who will sit with you and help you think out loud without making you feel foolish for being afraid. He called me 3 weeks later to say he'd met with Patrick, that he'd had the documents reviewed, that there were, in fact, several provisions in the trust that would have given his son unilateral control over his assets under certain conditions. He said, I thought I was being paranoid. I know, I told him. That's exactly what they count on. My house still stands. The raised beds my husband built in the back garden are still there, a little weathered now, and I've started growing a second variety of tomato this year in addition to the ones I always plant. The furnace makes its noise every October. I know what it is now. I had a technician explain it to me properly. It's just the metal expanding as the heat comes on. Nothing wrong. Just the house reminding me it's still here. I'm 68 years old. I have a good lawyer, a fierce neighbour, a daughter who calls twice a week, and a clear-eyed understanding of my own worth that no one will ever talk me out of again. They counted on me being too polite to ask questions, too grateful for the help, too old to notice. I noticed. I think about Marion a lot, about the way she went still when I said the words "bare trust" over the garden fence, like someone who'd heard a door creak in a house that was supposed to be empty. She didn't panic. She didn't tell me I was overreacting. She said, "Come inside." And that steadiness, that calm, clear-eyed refusal to dismiss what her gut already knew, is what I keep coming back to when I try to understand how any of this unfolded the way it did. There's a version of this story where I sign the papers, where I feel too embarrassed to question the language, too grateful for the attention, too conscious of not wanting to seem difficult or suspicious of people who were, on the surface, only trying to help. That version ends very differently. That version ends with my house gone and a lawyer explaining to me, gently, that what happened was technically legal because I had consented. I didn't sign, and the reason I didn't sign wasn't luck. It was that small persistent feeling that something was off and the decision to take that feeling seriously instead of talking myself out of it. I've thought a lot about what allowed them to get as far as they did. They were counting on a specific kind of vulnerability, not weakness exactly, but the particular isolation of grief. When my husband died, I lost not just him, but the person I'd always talked things through with first, the one who would have read those documents at the kitchen table and asked the questions I didn't know to ask. They saw that gap and they walked right into it, offering exactly what grief makes you want: someone to lean on, someone who already knows your family, someone who seems to understand your life without needing it explained. What stopped them was 3 things, and I don't think any one of them would have been enough alone. It was Marion's integrity, her willingness to tell me a hard truth without softening it into something more comfortable. She could have said, maybe it's fine, maybe I'm wrong, let's not make a fuss. She didn't. She said, this is what I know, and you need to hear it. That is a form of moral courage that I don't think gets named often enough. Doing the right thing for someone else, even when it would have been easier to stay quiet. It was Patrick's knowledge and the clarity he brought to a situation I couldn't fully read on my own. Intelligence, real intelligence, isn't just knowing things. It's knowing how to use what you know in the service of someone who needs it. He took what I brought him and he built something out of it. He didn't make me feel foolish for nearly being deceived. He made me feel capable of fighting back. And it was something in me too, some refusal to let the discomfort pass without following it somewhere. I recorded that conversation. I kept the appointment. I let myself be afraid and did the work anyway. That's not bravery in any dramatic sense. It's just not giving up on yourself when the easier thing would be to go along. What happened to those two people was the direct result of what they chose to do. Not fate, not bad luck. Choices, made deliberately, over months. And the consequence followed from those choices the same way water follows a slope. I don't feel satisfaction about their sentences exactly. I feel something quieter. I feel that the world, in this one instance, worked the way it was supposed to. I am 68 years old. I have a house, a garden, a daughter who calls twice a week, and a neighbour who will come inside immediately if I ask her to. That is not a small life. That is everything.